The views expressed are not those of local community broadcasting, WYML LP, or its management, volunteers, or underwriters. Greetings and welcome back to the Personal Safety Show. This is Marcus Melnick, your host from Firearm Mentor and Stress to Logic, and we are continuing the conversation with attorney Fred Nickl from Nickl Williams, who focuses on restoring FOID rights as well as other regulatory rights in Illinois. So this is the continuation of the conversation right where we left off. How long do appeals typically take?
It depends. If it's a records challenge and I'm handling it, I'm not saying I'm going to do it better than anyone or anything like that, but I will direct that after it's sent down to the state police. I will follow up with certain people who may be able to go look at that and have that appeal granted within a couple of weeks. The fastest I ever won one was for a client who was law enforcement, because there is in the FOID card statute the ability to, and I'm blanking on the word, not accelerate, expedite an appeal if you're in law enforcement, because the thinking there is you need it for your job.
Right.
I think I had one go live within 24 hours once. But generally, for your standard, if we're going to the FOID card review board, 3 to 6 months, maybe 2 to 5 months. If we're going to court, I always say expect 6 months from when I filed the petition to when we get the hearing. And we almost always learn on the day of the hearing whether we've won. Occasionally, a judge will, if it is complicated, will take some time to write the order out, but that gives you an idea.
Excellent. And society has changed over the past several years, more so recently, with cannabis being decriminalized in multiple states, including Illinois. And we recently saw the Hunter Biden case where he possessed a firearm while he was addicted to drugs. What's your opinion on that case? Is that case going to be like a landmark case, or was it just like a one-off and he happens to be a prominent person?
It's the second. I mean, that is a standard thing that happens. Generally, if they've got you, you plead. And my understanding, I haven't followed that case closely, but my understanding was he did try to plead, and the judge rejected it for whatever reason, and then he had to go to hearing and lost. I think Hunter knew from the get-go, at least if his attorneys knew what they were doing, they were telling him, this is a losing case. It is black and white. This is not something where there's a gray area. There are considerations in the future if cannabis or marijuana is reclassified as a different level controlled substance. How will that change things? That's all up in the air. But for that specific case, I think everyone who does any of this knows, oh yeah, he should either plead or he's going to lose at trial. And you just don't generally see it get that amount of attention because, you know, that's what you call a heater case. That's someone who's recognized nationally, and so everyone pays attention to it. But that's not uncommon.
Very good. I'll share with you something that I recently said on social media. Well, it was in a chat. Someone asked, well, if you owned a gun store and Hunter Biden came in and passed the background check, would you still sell him a firearm? And I said, as long as his money is green and his nose isn't white. And that was me kidding. I'm teasing.
Right.
So a lot of people like that in the group. I got some mileage out of that. Can you talk about the Rahimi ruling that just came about?
I can say, so when I first heard about that case, and I apologize if you can hear my dog.
That's okay.
That's going to change there. My wife is grabbing the dog. When I first heard about that case, I thought, wow, I assume whoever was behind pushing this case forward and pushing it up to the upper level into the Supreme Court and all that, generally you're going to have Second Amendment money that's helping with that. I assumed they picked the perfect plaintiff or perfect defendant, right? Until I looked at this guy's background.
Right.
I don't know the man. All I know is what was listed in the complaint. But there were allegations of shooting and keeping guns and then saying, oops, I didn't realize that I shouldn't have had these guns. Multiple firearm offenses in the background.
Right.
That's not who you want to take up on appeal. You want to take up the little old lady whose boyfriend at age 70 took out an order of protection on her, and now she's appealing that up. Similar to the Johnson case that led in Illinois to the Supreme Court saying, hey, you're not locked out. If you're a domestic batterer, you have a right to file an appeal, which for a few years there we didn't have. So I am shocked that they took that case up because it were really bad facts. However, it makes sense that there is going to be some limits on that. So as a liberal, I'm glad it was decided that way. As a person who's out in public, I'm glad it was decided that way. But if it was different facts, I could definitely see how maybe Supreme Court ruled a different way, for sure.
Very good. I actually agree with the ruling. I mean, if he's got a history,
yeah, it makes sense.
Yeah,
right.
It's, to me, that's black and white. That's not gray area. But I'm not an attorney. Yeah. So there's a ton of what I will call social media influencers, and I actually put myself in that category. And they're well sponsored, and they keep putting out breaking news. Somebody filed an amicus brief, and that doesn't mean anything to the general public. The news is often one-sided, and it's hype, it's rhetoric. What are some good resources to obtain updates on some of the cases that are currently in the court system?
That's a good question. Generally, in the past, if I was interested in something, because I have a PACER account, PACER is the electronic filing system for the feds, you used to be able to do this. I don't know if you still can, but you used to be able to add your email address as kind of like an interested person, and anytime there was a filing or something happened, you'd get a little email alert. And that was amazing. Now, I haven't done that in a while. I don't know if they still have that ability to do that. I do know anyone can register for a PACER account. So that might be one way to do that. And that way you can see, oh, gee, yeah, there's amicus briefs filed on everything these days.
Right.
They'll have 20 from this side and then 20 from the other side, and it kind of doesn't make sense anymore. Otherwise, really, you've got to follow someone on, I hesitate to say X because I don't like Musk, but, Twitter or Instagram or a good legal blog, someone who isn't out there just for the clicks,
right,
and follow their updates. And if the updates seem to be neutral and not advocating for one way or the other, then you're getting the updated information. But you're right. There could be 50 amicus briefs filed on a certain case, and none of them mean anything.
Right. Do you work with any of the major insurance plans, Right to Bear, U.S. Law Shield, USCCA?
So, yes, we worked recently with, here, let me look at my notes. We worked recently with CC. What?
I know what you're talking about. I forgot what it's called.
Let me get the name here. And I've had people reach out to me from the other ones. Mm-hmm. Here, I'm blanking on the name. Okay. Oh, here we go. It is CCW Safe.
Yes.
And we had some success for some of their insureds. I've had other folks reach out to me as well, and I don't know if they just don't like the fees I quoted them, or if they would rather their insureds pay for it, and then they reimburse them later. But at least with CCW Safe, if it's a self-defense, they will pay. They will pay the attorney. They will pay the expert if needed. So I haven't evaluated any of these, but that's the only one that I've actually had some recent experience with. Okay. Anyone else who's reached out to me is just, never really followed up.
Well, if you ever have a question, I got my ear to the ground on those. We can talk offline. I'm happy to give you my opinion, which is just an opinion.
Sure.
So cool. So several years ago, we had red flag laws that were initiated, and one of my fears is that someone's going to have a bug up their rear end and say, I don't like Marcus, he has guns. And have you seen any, and I have not heard of this, but you're closer to the court system. Have you seen any abuses of red flag laws with false complaints?
No, in fact, now, first off, I don't do the hearings on red flag petitions, and that's because I'm not set up like, say, a criminal defense attorney who's always in their car. I just can't drop everything and show up at Skokie,
Right.
or no. So I generally will refer those out. But I can tell you, I've maybe had 3 or 4 calls since that came out, and when I ask, okay, well, what's the allegation? It's always something relatively severe. To me, it always seems like, that's probably a good use of that. I have never heard from anyone that said, I got into an argument with someone and they're using that. And I've talked to my colleagues. No one's heard of any abuse of that. What there is abuse of is the clear and present danger reporting. That is the biggest thing going on right now. And if you want me to talk about it, I can.
Sure.
I will.
Floor is yours.
I can tell you that before the Highland Park shooting, I got 1 call a year with a clear and present danger prohibitor. Clear and present danger is a report that either law enforcement, a school administrator, or a physician can file. It goes to the state police. The classic once-a-year call was, I got drunk, I stripped down naked, I grabbed my gun, I ran down the middle of my street screaming, I'm going to kill everyone. Well, to me, as a civilian, that sounds like a clear and present danger.
Yes.
And we generally didn't, no one wanted to hire me because I'd tell them, look, you're kind of screwed. Let's wait a little bit. When the Highland Park shooting happened, ISP, Illinois State Police, got embarrassed, and because that shouldn't have happened, right? That Creamy or whatever his name was shouldn't have had a firearm. And you can assign blame wherever you want, but the Illinois State Police did something that was a little overboard. They changed the rules, or they added a rule that said, essentially, I'm going to paraphrase, we've been evaluating these clear and present danger reports for years, and we've only acted on the ones we thought were legitimate. We will stop doing that. We will exercise no discretion. If a clear and present danger report is received by us, it will result in a FOID revocation. So the week after the Highland Park shooting, my phone rang off the hook. Everyone else's phones rang off the hook. The Illinois State Police had gone back retroactively for 5 years, and anyone who had a clear and present danger report, they revoked them all at once.
Wow.
And now, anyone who gets one is revoked immediately. There's no discretion. And what we have found out by looking historically at these is that, and I'm not bashing anyone, and I know some of these reports are probably legitimate, but 99% of them were by police officers, not just Chicago, not just the suburbs touching Chicago, but kind of all over. If you got pissy, sorry, hopefully I can say that, with a cop, if you pissed them off, you got a clear and present danger report. If they knew you had a FOID card. I talked to a security guard who was home. He was an armed guard, came home, was eating dinner. His wife made him dinner. He heard someone rummaging around in their garage in the city. He ran out the back door. There's a little patch of grass, saw the light on in the garage, and he yelled, "Get out of my garage. I'm armed." The person in the garage threw something at him, came through the window, glass shattered. He didn't know if it was a firearm or what, if he was getting shot at, so he fired a warning shot. Person ran off. He called the cops. Cops arrived, and the cops said, "What are you doing firing a warning shot? You don't have the training like us." He was a little upset, said, "Who are you to say that?" Guess what? He got a clear and present danger.
Wow.
Because he had a firearm. And if you were in a road rage incident where someone flipped you off, so you flip them off, and they call the cops, and then the cops stop you. No arrests. No one's getting arrested. You're maybe getting a little talking to. 10 minutes later, that clear and present danger report was being filled out and submitted. It is brutal. And I have talked to some people that want to challenge that. When you talk about challenging the state, it's expensive.
Yes.
Because the state always has their free lawyer. But that, to me, is the biggest violation of folks' rights, because the clear and present danger report is not discoverable. So you're going to have to go to hearing without knowing what it says. Occasionally, if you go to the Northbrook PD and file a FOIA, they might not realize that those are confidential, and they'll give it to you. That only happens like 5 to 10% of the time. The state police knows it's confidential. They won't give it to you. All they'll tell you is the month and of when it was filed and the police agency that filed it.
Wow.
And the FOID card review board, I have problems with them, and I have no problem going in public and saying this because I'll say it to their face. They believe anything that a police officer writes.
Right.
And we have had to go to hearing, and I have had to call eyewitnesses to say, no, that's not what happened. Here's 5 people to say that when that cop walked over to my client and started a little argument, it was just ego-driven. Nothing else had happened. And lately, the FOID card review board is starting to maybe understand that they're relying too much on what the police officers write in those reports. But it is the worst thing going on in Illinois right now.
Awesome. I did not know that. Thank you for educating me and the listeners.
Sure.
What final thoughts can you share about the Second Amendment, or maybe something I didn't ask that you would like to talk about that I should have asked?
Well, I get a lot of calls with people that do their research, and the research only goes so far. So they'll say to me, look, I think I should have had my FOID given back to me automatically. That is like a huge misconception. You always have to file an appeal. Even if you lost your FOID because of an order of protection that then expired 2 days later, you still have to file an appeal. That's one misconception I wish people understood better. You can't just. I've talked to folks that are like, Fred, I've been paying the $10 every year, and I reapply every year. It's been 15 years. When are they going to give it to me? And I say, well, you waited 15 years too long, and you spent $150. $10 times 15. You didn't have to do that. All you got to do is file an appeal. The second misconception is that federal convictions still allow you to file an appeal. That's that 0.1% I mentioned before. If you have a federal conviction, I can't help you. You need to first get a presidential pardon, executive clemency. I don't know anyone that does that. The DOJ has a website that'll give you the 35 things they need to look at. Maybe do it yourself and come back after that. And then the final thing is there is a significant case, the Snedeker case versus Will County, that no one seems to know about. I post on Illinois Carry. Marcus, do you know that website?
The website or the Facebook group?
Well, there's a website with a forum, and you can post in that forum, and they've got dedicated channels for FOID appeals, CCL appeals. The person who runs it or the moderator goes by the handle Molly B, but I've talked to her offline. To me, that's the best place for me to kind of put this stuff out there. There's also a Reddit channel that I try to put some stuff out there if I don't post it on my blog. But the Snedeker case says that if you have to do a FOID appeal, that is a formal appeal. So meaning you've got a domestic, a weapons offense, or a drug charge that was class X1 or 2, and you don't live in Illinois, you are SOL. All you can do is move back to Illinois and then file your appeal. It was never like this. I had to educate the state police and point them to their statute years ago because they were misinterpreting it, and they fixed it. And if you called me from out of state and said, hey, I can't get an Arizona permit, or I'm in Minnesota and I can't get my permit here because I have something in Illinois, I'd say, great, we're either going to do this or this, and it was fine. Here's what it costs. Here's how long it takes. Here are your odds. Now, if you call me out of state and it's something that I'd have to bring you into court for, that Snedeker case screwed everything. You have to move back to Illinois, and you can't fake it. You're going to have to show a new driver's license, a lease, or a deed, or something. So it'd be love for people to understand that, maybe put some pressure on whoever. I assume this is eventually going to get fixed. But for right now, it's really shutting out a lot of folks with things in their past that they can't fix.
Interesting. So, for anyone who would like to reach out to you or need your services, can you provide your contact information, including the spelling, because you are missing a vowel somewhere? That was me
I
kidding.
am. It's so, you know, if I'll talk to anyone free of charge just to tell you where to go or, what you need to do. The website is williamsnickl.com. Williams is the easy one. That's the common spelling. Nickl is Nickl. However, because no one can spell my name, I also have a sister website that's easier, and that's FOIDappeals.com. Everyone knows how to spell FOID, and they should know how to spell appeals. That'll get you to me as well, and you can shoot me an email, and I'll shoot you an email back. If you want to give me a call, and I'll give you no-charge advice. Hey, this is the kind of appeal you need to do. If you don't like me, here's how you do it yourself. There's a couple of other lawyers that do appeals in Illinois, but just a couple. And yeah, absolutely. I'll talk to anyone.
I will slightly disagree with you. Not everyone knows how to spell FOID. I can't tell you how many calls I get. Hey, I'm trying to get my Floyd card. What's a Floyd?
Really?
Oh my gosh, yes. And it's not just one time. It's like every month I get a call or two about the Floyd card. I think it's funny.
Food appeals.
Oh.
Autocorrects food. Or what really annoys me, and I am a little persnickety, is it's CCL, not CCW.
Yes.
And I know CCW in many states, but in Illinois it's a CCL. And so I'm always like, oh, okay, call them for your CCW. Yes, I can help you with your CCL.
Right, totally. That's like the magazine versus clip. In my classes, if you call a magazine a clip, I tell people, I'm going to stick my tongue out at you. And then I had customized binder clips made that say, this is a clip. And then I hand out.
Awesome.
Yeah, if you didn't figure it out, I use a lot of humor when I teach. But thank you very much for taking the time to talk to our listeners about what you do, how you help people, and how you bring people back to a sense of normal. Appreciate your time.
Absolutely. Thank you, Marcus.
I want my listeners to know that this is my dream, teaching people about safety. If it weren't for you, if it weren't for my listeners, I couldn't live my dream. So on behalf of my family and myself, I want to thank each and every one of you for allowing me to live my dream. And I also want to continue to live my dream, and I'm excited to continue to spread the word of safety. Recently, I began a new service as a conference keynote speaker. So if anyone would like for me to speak at future events, or if anyone knows of an introduction or would like to discuss how we can work with one another, I'd love to do just that. The keynote speaking website is www.stress2logic.com. That is STRESS2logic.com. If you're aware of any conference speaking engagements where you'd like to have me speak, I'd love an introduction. You can always share my electronic business card, which is Marcus Melnick, MarcusMelnick.com. Now, back to the show.
And I do like to go to garage sales, and this past weekend or last weekend, we were at a garage sale where they had a number of pellet guns and BB guns, and my wife out on a table, and my wife looked at it and said, "Ooh, can they sell guns at a garage sale?" The answer is yes, you can sell firearms. These are not firearms, though, according to the Illinois statutes. In order to be considered a firearm, it has to be able to launch a projectile with the action of expansion, explosion, or escape of gas. And an air gun, as long as it's less than 700 feet per second, you do not need a FOID card for. If it's a caliber larger than 1800ths of an inch, you do need a FOID card for. So a lot of BB guns and pellet guns, the caliber is .177 or 177 thousandths of an inch instead of 180 thousandths of an inch. So it goes right below that threshold. So my wife was saying, wow, I didn't know that they could sell that. And you can. You can walk into a Walmart, even a gun store if they're selling small guns. So what does 700 feet per second mean? And actually maybe 750. Just to give you an example, I have an air gun. It's a pistol. And maximum, it goes 450 feet per second. And that's when the cartridge is brand new, the carbon dioxide cartridge. As air gets used, there's always some leakage, and it gets less and less and less. So the air guns that require a FOID card are usually 22 or 25 caliber and go more than 750 feet per second. For those, you would need a FOID card for. So I love going to estate sales. If you have an estate and you need to know what the value of something is, let me know. I am not a gun dealer, but I do have the Bible. Who knows? Maybe I'll buy it from you. Maybe I can introduce you to someone who is properly licensed to buy it from you. So you can always reach out to me via my electronic business card. That is marcusmelnick.com. That is MarcusMelnick.com. And in 2 weeks, on the 20th and 21st of July, we have our next concealed carry class. If you're interested, you can sign up at www.firearmmentor.com/classes. I hope to see you there. We have monthly concealed carry license CCL classes in the northwest suburbs of Chicago. Dates can be seen at firearmmentor.com/classes. If you have a question, we can be reached at www.firearmmentorcard.com. That is our electronic business card, has all of our contact information and links in it. It's the easiest way to get a hold of us. Until next time, stay safe out there, and I'll see you at the shooting range. This is Marcus Melnick from Firearm Mentor signing off. The views expressed are not those of local community broadcasting, WYML LP, or its management, volunteers, or underwriters.